It's been more than a decade, I'd say.
Okay, we're just gonna leave it at that. More than a decade. I have learned so much from her, and I know without a shadow of a doubt that you are going to just not only enjoy her as a person, but as an expert who I think in her sleep she just loves cats and wants to help people. And that's why I am delighted that you are with us this evening, Mary
course.
Frances. Thank you. So would you join me in just giving a warm, heartless welcome to Mary
Thank you.
Frances? Thank you.
Yes, thanks, Mary. Okay, well, I elected to take my mask off, which means I have to stay back here. So hopefully you can hear me okay. So I'm going to start with just a little story. This afternoon I met with a family, Dad, who's 92. He brought 2 of his 5 children with him, and then one of the sons-in-laws came with. And he's pretty organized. He lost his spouse recently, and so he proudly handed me his existing estate documents along with some other information I had asked for. And so I was looking at what he had there, and he had a will. He has a will, and then he had a document from Ameriprise where he keeps some of his investments, and he had a document from Wells Fargo. And so I was looking at those 2, and one of the documents was Ameriprise has their own power of attorney. So he appointed one of his kids as a power of attorney, and then the Wells Fargo document was a bank statement, and it said Dad's name, and then it was joint with 2 of the kids, the 2 that happened to be there. So he wanted to make sure, everything was in order, that if anything happened to him, he actually has capacity, he's totally able to manage his affairs, but he's thinking about the what ifs I can't. So I'm going to refer to this example as we start talking through some of this stuff because, well, first of all, what do you think about that? Because he said, well, we don't need any power of attorney. I just want you to review my will. I don't need to do a general power of attorney because I've already done that at Ameriprise. What do you think about that? Is that enough? It's enough to let that 1 or 2 children call the Ameriprise advisor, but could they sign a contract to admit somebody at the fountains with an Ameriprise power of attorney? No. So sometimes, these designation of agents, it's getting more confusing, right? So hopefully what I'm going to try to do today is give you some practical advice for you in terms of what documents are really important if you want to have a good, thoughtful plan in place. So the first thing is I'm really only going to focus tonight on documents that are directives for appointing someone, 1 or more people that we trust to help with supported decision-making while we're alive, while we're living. After death, something different happens, right? So things like power of attorney, healthcare directive, post, those are some of the things we're going to touch on tonight. Those are only effective when somebody is alive, but after death, they are extinguished, okay? So when you hear that word incapacity, what does that make you think of? Incapacity. Who do you think gets to decide when somebody's incapacitated? Is it the family? Is it the lawyer? It's actually the doctor. So incapacity is a clinical term, okay? It's a clinical term. There's a different term at law for determining whether somebody can manage their own legal and financial decisions, and that word is incompetent. It's kind of a negative word, isn't it? Incompetency, people who are incompetent at law include people under 18. I have an 18 and a 15-year-old, and I think most of us that are parents agree that, yeah, that group is incompetent, right? They're what's called incompetent at law because, my 15-year-old, can she make good decisions for herself? Sometimes, but not reliably and not consistently because she's incompetent until apparently when you attain age 18, you are now competent. So I think we might need to push that back a little bit. But anyways, incompetent is a legal determination, okay? And incompetency, as you'll find out today, is something that only a judge in a court of law can determine. So what happens more commonly in practice when we're working with our families and our friends and our loved ones that are aging and thinking about the potential need that they might need supported decision making, we're really talking about capacity. So when you think about things like power of attorney and healthcare directive and appointing an agent, it's because we're planning for the potential that we might be lacking capacity. Okay? And when you do planning like powers of attorney and healthcare directives, the goal is to never have to go to court, to never have to go before a judge. But there are circumstances where if people don't do the planning documents, we end up in court, or if there's a conflict. So even sometimes when people do planning, there's conflict that can arise. And I'll share some examples of that. So the documents that I'm frequently working with my families include powers of attorney, health care directives. There's a provision in sometimes a separate document that's referred to as a DNR, DNI, do not resuscitate, do not intubate. And then there's something called a POLST, P-O-L-S-T. And that's our sort of roadmap of where we're going to go today, what we're going to talk about. And I'm going to start with those financial powers of attorney. So there are really two forms of powers of attorney in the state of Minnesota, and in many states, but I'm going to focus on Minnesota. We have something called a statutory short form power of attorney. That's statutory means that the Minnesota legislature adopted a form, okay? And so if you Googled Minnesota statutory short form power of attorney, you'd actually find the form, okay? It's on the Attorney General's website. It's available in the public domain. And the reason states make these uniform forms is so that it's very easy for places like Driver and Vehicle Services, Wells Fargo Bank, the Office of the Registrar of Titles in the county. Like everybody knows what that document looks like, right? Because it's standardized, it's uniform. Whether you have it done at law office A, B, or C, it looks the same. So that's our statutory power of attorney. That is very limited in scope in terms of how it can be used and for what purpose. And I'm going to guess many of you may have this or have seen the form. It has a checklist on it, A through M, and you can check only the things that you want to apply, or you can check N, which is all of the above. But in any event, that type of power of attorney is very limited to that little list. And sometimes there are things that we need to do that aren't on the list. And for that reason, some people also need what's called a common law power of attorney. So a common law power of attorney gives you the opportunity to work with your lawyer to say, well, here's what I have in my estate, and here's who's in my trusted network of support people. Maybe it's children or friends, or you have a professional helping. But we look at what's in the estate, who are the helpers, what are your planning goals, right? What is your health status? Are you likely to become incapacitated? Do we have a health condition that we know you're going to have progressive loss of cognition? And then we might draft that document in a way that recognizes and supports what we think your unique needs would be. And in any event, it's much broader. So a common example I see is a statutory power. You can only transfer assets up to $16,000 in a year, even to a spouse. Like if a spouse is using a power of attorney to access something like an IRA, a marital asset, and they want to move money into their name, the well spouse, let's say, they're limited to $16,000 unless they have a power of attorney that says my spouse can transfer property from our marital estate without limitation. Okay, so a lot of times I'm working with spouses who I'll say, do you want your spouse to have full access to your marital estate? People are like, well, yeah. You don't automatically have that just because you're married. Okay, so that, we each, if you own any retirement assets or something that's in your name alone, I'm working with a family right now where one of the spouses, the wife, inherited a quarter interest in a farm. And it's in her name alone because she inherited it from her father. And they're thinking of doing something in their estate planning, and he has no legal interest in that, and she has some memory loss. He luckily has a power of attorney where he can do things with her 1/4 interest in the farm because he has the right power of attorney. But just because he's married to her, if he didn't have a power of attorney, would he be able to sign off on the sale of that property? No, right? No. So it's things like that where you may need to have a broader power of attorney, giving somebody that you really trust authority to do things that are beyond the scope of what that limited list is on the statutory form, okay? And where I see it really becoming important is when I'm working with families on long-term care planning. Okay, long-term care planning is kind of a generic term for, I see a lot of families that are paying for assisted living, paying for memory care, paying for home care, and they're trying to build a budget and a plan to protect assets, maybe for the spouse who's living at home, the healthier spouse. Maybe we're trying to apply for veterans benefits, maybe eventually medical assistance, and needing to move property around permissibly, right, legally. I'm not talking about let's hide it, or let's, I'm talking about permissible legal planning that you may want to do that's sensible, but if you don't have a power of attorney, you might not be able to do that, okay? So again, that statutory short form, sometimes people say, well, Mary Frances, we have the statutory and the common law. The common law is so much broader. Why do you make me do both? Why don't I just do the common law? Well, the reason I recommend the statutory in all cases is because it is so easy to operate with. It's in about 10% of circumstances where we might not have sufficient authority. I just don't always know when or for whom that is. So we have that as kind of like the big gun, the backup. But the statutory power is so easy to operate with in our state because everyone recognizes it. You walk into the bank, you present it, everyone knows the form. Question? So the question is there a limit of time? The statutory form allows somebody to put a limit on it. Okay, you are allowed to do that. But if you don't fill that out, then it's unlimited. It's presumed that it's forever. But what happens a lot of times is banks will say, well, that was done 15 years ago, it's out of date, or that was done, you have to do a power of attorney every 5 years. That is baloney. Okay, that is something that the banks use to cover themselves from the potential liability. But what happens is sometimes I'm working with a family that, has a power of attorney that somebody did and now they have advanced dementia. There is no signing a new one. We don't have that option. And so legally, if there's no expiration date, it's still permissible. It is still valid. Absolutely. I've worked with powers of attorney that are 25 years old. They're still valid. Now, what about if you move mom here from Wisconsin and she has a Wisconsin power of attorney with advanced dementia? Can you use the Wisconsin power of attorney here? Answer, yes. If that power of attorney, and Wisconsin I'm just picking on because it's our neighbor, but it could be any state. Any state, Minnesota will recognize a power of attorney that was validly executed in the state in which the person was a resident at the time they signed it. Okay, as long as it's valid under that state laws, it will be recognized here. Now, sometimes people move and they become a Minnesota resident, they have the opportunity to update, and then I would say, do the Minnesota statutory form, just because it is so much easier to operate with. But we are seeing in increasing numbers, clients calling saying, XYZ bank told me this power of attorney has expired or is too old or something like that. That is untrue. That is the bank's individual policies. And actually, again, one of the benefits of the statutory form is that if somebody refused to accept it, there's a remedy under law. Okay, that sounds like lawyer speak for we can threaten the bank and say, if you don't accept this, there are penalties, financial penalties that you will be subjected to if you fail to accept this as a valid instrument. So that's another benefit of having a Minnesota statutory form is our law protects, the use of that, the ability to use it. okay, if somebody tries to reject it. So when you think about the family I met with today, they thought, we got this covered. We got 2 kids joint on the Wells Fargo accounts, which has its own problems, by the way, right, potentially. But my client's thinking, I got the Wells Fargo covered, I got the Ameriprise covered, because my Ameriprise advisor had me fill out his internal one. And I said to them, okay, let's say you develop dementia or you have an accident and you're in the hospital and you don't have capacity, and you've got this car that your kids decide, we don't need the car anymore, let's sell it because dad's never going to drive again. I said, do you know, how would the car be sold if you can't sign the title transfer? And there's crickets, right? Oh, I didn't think about that. What if you need to sign an admissions contract and a payment contract for somebody with advancing dementia to admit them to memory care or nursing home or accept, and pay for home care? Can you use an Ameriprise power of attorney for, moving into assisted living? No. So really best practice is having a general power of attorney, right? And, your Ameriprise advisor or Fidelity or whomever may also request you fill out another form for their internal purposes. And even though that might not be required under Minnesota law, a lot of times I'm like, it's the path of least resistance. I'll assure my clients, do their internal form, but also have this general power, because there are things that come up that if you just do that limited power and you think you're covered, it's not comprehensive. But the Minnesota statutory is, on that list, right? And so it's broader, it's more general. It'll say things like banking transactions. Well, that could apply to Huntington, Wells Fargo, wherever, Wings. And so it's not just limited to that one institution. So having a more general power is best practice. Yes.
So, just so I'm understanding you correctly, you're recommending people have both. So in our case, my mother did a POA years ago, but if we have no statutory, you're saying do a statutory now?
So the question is, am I recommending both? It really depends on what's in the estate, right? So for example, if I have somebody who has $50,000 in the bank and an IRA, and we're just drawing that down, paying for care, a statutory short form might be just perfectly fine enough. Now, if I have somebody who's got $800,000 in different investments and a house, and one spouse at age 67 just diagnosed with something that's going to require a lot of care, and we have to start moving assets around, then I might need that broader power of attorney, because 10 years from now, we might need to move the house and other investments. So that's what I mean. I don't say one size fits all. Everyone should have the statutory, and then whether or not you have a common law is a determination you make with your advisors. Like, do we need that or not? Okay. And if you have a common law, you can probably just use that. It's just, as I said, the statutory is extremely convenient, but if you've had a power of attorney in place for 5 or 10 years and it's working, you're probably fine,
Do you have any advice on whether it's better to have all siblings on a power of attorney or multiple?
Oh, yeah, this is a good question.
One, so that
Yeah.
if multiple, how do you,
Yeah. So,
what are the pros and cons?
yeah, so power of attorney gives us the opportunity to appoint one or more persons. So I've had people through the years, I have 3 kids, I have 4 kids, I have 5 kids. I just want to name them all. Do I think that's a good idea? Absolutely not. Because it is, and it always depends on the family situation, but I think my strong preference would be 1 or 2, right? And if you have more than one person with equal authority, then the document has to say, must they act jointly, sign every check, sign every contract together, or may those 2 act independently? Like, I'm going to call the insurance company, you call this, that's divide and conquer. That, if you had 5 people with that authority, that could be a nightmare, right? Because you could have, my office could have 5 people calling on behalf of dad asking the same question, right? And so the potential for miscommunication or conflict or chaos goes up every time you add another person onto that document. So that's different than here's my primary, here's my first successor, here's my second successor, right? 1, 2, 3. So my personal and professional opinion after, more than 15 years of working with families is that's not a great plan design. I just had a situation, there's 3 daughters, mom and dad. Mom died, dad survived. He's got advancing memory loss. One of the girls has been the power of attorney for 10 years. Now dad's moving into memory care, and the 2 other sisters took dad back to an attorney, and the sisters asked the attorney to create new powers of attorney with naming all 3 of them. The attorney knew they were not getting along. He knew that the first daughter had been in place for 10 years and it was working fine, but he produced new documents naming all 3 of them with equal authority. Now money's going missing. It's like a mess. And they all have the legal authority to do different things. So somebody's writing themselves a check, somebody's paying dad's bills, and it's like an accounting nightmare. So that's not going to happen in everyone's family, right? But I do think you want to be thoughtful and practical. Like I'll tell my clients, okay, let's think about how this is going to be used and who in your circle are the likely people with the skill set, the time, and the talent, right? So you say, being a power of attorney is a job, right? If you're managing somebody else's life, their financial life, takes time. And so you want somebody who has time, who has some competency, right? Like you probably don't want the person who's had on and off addiction problems for 20 years, potentially, right? That might be a consideration. So, you want to think, okay, who's in my circle that maybe does a good job of managing details, managing their own finances, is available. And available doesn't mean lives in Lakeville next door. It means has time. I have powers of attorney that are in California, overseeing mom's affairs here in Minnesota, but they're retired, they're detailed, they're available in the sense that they're looking at the bank statements, they're making phone calls, they're taking trips here periodically. So it really depends on, but just keeping in mind that it's a job, right? And it's a job that if you have 5 siblings and one is serving as the attorney, in fact, and the other one's sitting there griping and, gosh, she took the day off of work and took mom to the doctor, and then I saw a charge for Applebee's on mom's card. I bet mom paid for lunch for her. And, it's like, this is the kind of crazy, that I see. And it's like, yeah, she just took the whole day off of work and mom bought her a $9 lunch. I think that's okay, Or, I get the calls where somebody the power of attorney wrote themselves a check for, $46, and then somebody's throwing a fit, the other power of attorney, one of the others, and then it come to find out, well, yeah, I stopped at Walgreens on the way to see mom and I picked up some Depends, and so I just paid myself back. Here's the receipt. Like, okay. So that's the kind of thing where you have to have somebody who's, can keep good records. If you have multiple people and they're not communicating, that can be a problem. So if you pick 2 and they are going to act independently, and I think too, sometimes people think, well, this will bring kids together. Like I've worked with couples with second marriages, and they're like, well, I'm going to have my son and my daughter. They have to act jointly. And I'm like, oh, no. Maybe that would work. But in some cases, it, creates the potential for conflict. So I think you just want to be very practical when you're setting your power up about like, okay, what am I asking these people to do? And am I putting them in a position, where it could cause some conflict among the people I'm naming, And then it's always, of course, ideal to talk to the people you're thinking about nominating. Because, by the way, if your name is on a power of attorney, do you have to do it? Do you have to? If my mom says Mary Frances is my agent and she's in memory care, am I legally obligated to do that? No, it's a nomination. I can say, I can't. My brother's second in line, I'm going to resign, and he gets the nomination and gets to decide if he can. So you're not legally obligated to accept the nomination, but if you do, then what? If you do, you're expected to honor your fiduciary responsibilities to the principal, which means to act as an ordinarily prudent person would act, to keep the principal's utmost interest at the forefront of every decision you make. Well, oftentimes we're calling on family members, right? And there's an inherent potential for conflict of interest, right? So, for example, if you have a child who's serving as an attorney in fact, and there are multiple other siblings, and they're being paid for that, there's the potential that that could cause a conflict, right? Because the more activities they do, the more they get paid. So, and by the way, does anybody know who commits the overwhelming majority of financial abuse of vulnerable adults? People with a power of attorney. Okay, people with a valid power of attorney. So most of the time when we're dealing with cases where somebody has caused another person financial harm, they had a document that gave them permission to write checks or do things, but they misused it. They misused it. They abused their power. They breached their duty. So that's why powers of attorney, while they're like incredibly useful and powerful and important, we have to be careful. Right? We have to be careful about who we appoint. Now, you do get to choose when you set up your power. Am I going to give this person or these people permission to self-deal? Does anybody know what that term means, self-deal? That's a legal word for if I'm using my mom's power of attorney, if I can self-deal, I could write a check for $16,000 to myself. Okay, that's self-dealing, right? And sometimes parents will say, yeah, you can self-deal if it's consistent with my past practices. For example, mom has a pattern of giving everybody $100 on their birthday, and the child is serving as the power of attorney. Do they get to write themselves a $100 birthday check? Yes, if they have the power to self-deal, okay? So you get to decide. And then I had a couple in earlier this week. They have no children. They both got married in their mid-50s. By the way, I'm like, oh, they're going to be able to retire early and I'm like, kids are an expensive habit. You guys, that was a pretty good decision. But anyways, they have no children. So when they're thinking about, they were appointing nieces. So they're like, well, we don't need them to have a self-dealing power. They gave it to each other, their spouse. Yeah, you can self-deal. But beyond that, they were like, well, no, we just, they have a nice estate and they'll probably never run out of money or need to do long-term care planning. They just need somebody to help if they aren't unable to manage their affairs. So they decided, we don't need self-dealing. That doesn't make sense for us. So self-dealing, and then on your power of attorney, you can specifically say, do I want to allow gifting? Do I want to allow gifting to anyone, right? Do I want my person named in the power of attorney to be able to make gifts to anyone, including themselves, including the church? So standard language I see would be, I give my agent the authority to make gifts that's consistent with my past practice or past pattern of giving. So somebody who regularly contributes to a charitable organization or gives grandkid birthday cards and things like that, then if they've allowed gifting with that limitation, then their attorney, in fact, can keep making those type of gifts. And then I have people who say, nope, no gifting, can never make gifts. So that's something you want to address on the power of attorney. I made a note on page 2, the bottom bullet point, digital assets. Does anybody know what that is? Digital assets. It's the legal word for anything you have online. So online banking, Facebook, paying your cell phone bill, anything, any email, if you have a Gmail account, those are all called digital assets. And this is something that's relatively new, because what was happening, and you may have read about this or heard about it, it's like people were dying and then their family was trying to get control of their Facebook account, as an example, which had maybe 10 years of photos and posts. And Facebook was saying, nope, that belongs to the decedent, the person that died. You don't have access. Or somebody has dementia and a family member wants to take over a Facebook or an Instagram. Nope, that doesn't belong to you. So you have to have a power of attorney that says, here's somebody I trust to access my digital assets. And a Minnesota statutory does not allow that. It doesn't allow that. So then that's where like a common law would be needed for something like that. We're working on revising the statutory form, but when you get like 70 attorneys in a group to try and redo something, it takes a long time. And then we have to give it to this section and that, and everybody approves it. Then it goes to the legislature. So practical things like that, which should be included, take a long time to get implemented. So as of now, that Minnesota statutory form, you can't do anything with somebody's online presence, okay? So let me see. Oh, I wanted to talk about, has anybody ever, I've had people in my office that are, signing their papers like this, and they'll go, oh, okay, so now Mary Frances, this goes into effect when my doctor says I can't manage my finances anymore, right? Does that sound right? Does the power of attorney only get to be used once somebody's doctor says they can't manage their finances? Now I see a lot of no's, and you're right, no. Most powers of attorney are live and can be used the minute they're signed, even if the principal still has capacity, okay? There's, with one exception to that, there's something called a springing power. A springing power of attorney has a sentence that says something like, this document can't be used by my agent until a physician who has examined me certifies in writing that I'm unable to manage my finances. A letter of the physician is then attached to the document, and the authority is vested in the agent, okay? So that's the exception. The norm is they're live, right? The Minnesota statutory form, you sign it, it could be used right away. But on the common law, you can put in that springing language where it springs into effect once the doctor has written a letter. Now, why might somebody want to do that? Well, they may have the statutory form, which remember is pretty limited in scope. But if they have another power of attorney that's a bit broader, right? Broader gives a lot of permission, then they might put springing language in that document and say, this should only be used if I'm not able to, and then for the reasons I've specified. So some people will do that if they're, again, think about somebody naming a niece or a nephew, maybe even a child that they don't want to have broad access to their estate unless they're incapacitated, okay? So I'm looking at my example here. I've got Mary Frances, my mother is in memory care, and I have to access her IRA to pay for memory care. She's incapacitated, and I don't have a power of attorney. What should I do? What should I do? Let's say this happens, right? Daughter wants to take distributions from the IRA to pay for memory care. By the way, that's a really good place to draw down if you're paying for assisted living and memory care for tax reasons. So she's on the right track. But does she have authority to call Fidelity or Vanguard or Ameriprise and say, my mom's in memory care, it's going to be $7,500 a month, I just want an automatic deposit into her account, and then I'll write the checks from there because I'm on it? Joint. What is the advisor going to say to that child? I don't have legal authority to take direction from you about mom's IRA, okay? So if there is no power of attorney and mom can't sign one, then the answer would be something called conservatorship. Has anybody ever heard that term before? Conservatorship. In some states, they call it guardian over the property. Guardian over the property of a person. We, in Minnesota, call conservatorship. And so I'll give you another example. I had a couple that were married for more than 50 years. One daughter, adult daughter, they lived in Northeast Minneapolis and had a couple of rental properties. That was pretty much their estate, Social Security rental properties in the house. Mom had advanced memory loss. Dad had been her caregiver at home. She had a fall, a significant fall. She was hospitalized, and after a couple months in rehab, it became clear she was not going to be able to go back to their house with lots of stairs. It was not going to happen. So she was admitted to a skilled nursing home, and their plan all along had been, if the rental properties didn't produce enough income to pay for the nursing home, that they would sell one. So if any of you know that part of town, it's cliquey, right? And a lot of people know each other. So he had buyers lined up already, and he went to close on this private party sale, and he was the only one on the title, and he went to sign the documents. They were all set up for his signature and his wife's. He said, well, she can't. She's got advanced dementia. Well, title company says, spouse, have you ever heard the old adage, it takes one married person to go on title of real estate? It takes them both spouses to get out. So even if she's not on the title, she has to release her marital interest or right. So they were not able to close on the property. We had to petition the Hennepin County Court to get husband appointed as a conservator. And that was a court order that gave him permission to sign. If he had the power of attorney, it would have been fine. He would have been able to sign off. But they just never did that. They never thought about it. Power of attorney would have been, a couple $100. Conservatorship is in the thousands, even if it's uncontested. Because the court filing fee alone across the state of Minnesota is close to $400, just the court filing fee. That doesn't say anything about the attorney for dad, the court-appointed attorney for mom, which, by the way, dad pays for. Do you see what I'm saying? So to the extent that you can plan around court intervention, most families want to do that, right? But in this case, there was no alternative. If they wanted to sell that house, they needed to have permission. Now, if you might be thinking, well, that's stupid. If everybody agreed, why would they do that? The conservatorship process is designed to make sure that somebody like mom isn't being taken advantage of. So it's not like a horrible thing, it's just expensive and annoying when families like this are like, this was our plan all along. We all agree, we all get along, but the judge had to make sure that mom wasn't being financially taken advantage of, right? So there's a reason for those legal processes, but they are typically not preferred over just doing your own power of attorney, which is a private arrangement, and he could have closed on real estate had he had that. Okay. So any questions for me about financial or legal powers of attorney? Did you guys learn something? Oh, yeah.
Since the power of attorney is in a fiduciary position
Mm-hmm.
for the principal, look out for their best interests, don't they also have a fiduciary responsibility to communicate and communicative with the rest of them?
So the question is, if the fiduciary, the person serving as the agent, has a fiduciary obligation to the principal, do they have an obligation to be transparent with the rest of the family? Depends on what the document says. If the document says shall provide an accounting to these other people, and then they have to do that. If it doesn't, their duty of loyalty is to the principal, but they could be called upon under various circumstances to provide an accounting on behalf. So if there was reason to believe that it was misused or had been misused, then a family member could compel that person to provide an accounting. So if you accept the responsibility, you're not legally automatically obligated to produce an accounting and show all the siblings, for example. Some people do that just because they want to be transparent, but it's not legally mandatory. I've had situations where one child who's not the power of attorney will discover something that's fishy, and then we write a letter saying, hey, you need to produce an accounting to show us what's going on. And that is their legal obligation to be able to produce an accounting if called upon to do so under certain circumstances. But if the document doesn't specify must provide a quarterly accounting or annual accounting, then they may not have that legal obligation as a matter of default. Okay? So that's it depends on how the document was set up. Was there another question? Yeah.
What to keep the power of attorney person from using your funds for their own use?
Yeah, the question is, well, what's there to keep them from using the funds for their own use? Well, sometimes that's why we put an accounting requirement on. So like sometimes I'll have people say, I want, Mary Frances to be my power of attorney, but she has to give her siblings a monthly report, and so that they can kind of checks and balances. I have clients that don't have kids. They might have a professional power of attorney, and they send me an annual accounting, and then I review it. So sometimes people will do that, where they create this accounting so there's somebody else kind of overseeing what's going on. But you bring up a good point, which is that powers of attorney aren't like court supervised or anything. They're private, and that's why I said earlier, most people who are committing financial abuse have a valid power of attorney. They're just choosing to be naughty and misuse it and break the law. It's whether or not they get caught, right, will depend on whether there are consequences. Sometimes I see an astute banker or financial advisor who's looking at something and going, where did that $15,000 go? Oh, it went to the daughter. And so sometimes there's somebody in the person's life who might catch it, but you bring up a good point. If you don't build in an accounting and you've got one person or two, is it possible that they could misuse the document and steal money? Happens all the time. So you want to be careful. If you were like, I've had clients that say, I have kids, but they're not reliable, and I cannot rely on them or trust them to do this job. What are my options? Then we talk about other, friends or family, and if not, there are professionals. And I've had clients that are more comfortable with a professional. Yes, I have to pay, but at least I know that my funds will be, properly managed by somebody who's professional and licensed and bonded. So.
What if you're not able to keep track of
What if you're not able to keep track of?
an individual of your own funds? How do you know what's going on if you're not able to comprehend what you have and what you don't have and so on?
Well, that's why you would, so the question is, what if you yourself can't comprehend, like your estate and your financial management? That's why you might appoint one or more people to help you. You could appoint someone you trust to help you do bookkeeping.
So do you have two power of attorneys then?
Some people have more than one power of attorney. It kind of depends on who is in your network of support and whether or not they're available, and they'd be a good choice for that. So it looks a little different I know there's no one right answer here, So it can be tricky. So shifting gears a little bit, at the outset, remember I said Minnesota kind of breaks down supported decision-making into two broad categories. One is the financial and legal. That's what we've been talking about up until this point. The other area is healthcare, right? Healthcare, things to do with your body, your wellness, your healthcare decisions. Years ago, I had a client give me a magnet and had a picture of a woman that looked like my great aunt Ellen, who lived to be 101 in a nursing home in Indiana. Horn-rimmed glasses, went right from the farm. She was a teacher and a farmer, never married, right from the farm to the nursing home, lived there until she was 101. It looked like a picture of Aunt Ellen in the 60s, and it said, be nice to your children because they could be choosing your nursing home. Have you seen that before? Yeah. And that's true if it's the child who is named on your health care directive, okay? Because that's one of the things that the person named in that document has the ability to choose where you live. But fear not, because this is one where the doctor does have to make a determination of when that child's authority or when that agent's authority kicks in. Okay, the law is very clear. Patients are allowed to manage their health care decisions unless or until the doctor says they cannot understand the risks and benefits of treatment. At that point, it shifts into the agent's decision, okay? So Healthcare directives are a little different than the power of attorney because you do have the physician who's the gatekeeper. And I'm using physician as a generic term because it can be any physician who's examined you, okay? So if you're hospitalized and you see a hospitalist, that's the new thing, right? These physicians that see everyone in the hospital, that might be the person making a decision. Keeping in mind that sometimes people lose capacity during a hospitalization, right? Somebody has a UTI with acute delirium. Has anybody ever witnessed that or experienced it? Urinary tract infection can cause people to go kind of haywire. It's very fixable, but there might be this acute period of time where the patient really is not capable of making decisions. But then after the appropriate treatment, they'd be discharged and they're restored. Okay, so that's an example of somebody who loses capacity, but then regains it. But maybe during something in that journey, the agent had to make a decision, but then mom's discharged back to home and she's fine. Does that mean daughter gets to still keep controlling everything? No, right? Then as soon as the patient's restored, they can continue making decisions. When we're talking about progressive memory loss, it's a little harder because sometimes, somebody's got a good moment, a lucid interval, and sometimes they're having a bad day. And then with memory loss, sometimes we just cross a threshold where it's very clear that that patient is not capable of making decisions. But that's the doctor's decision, okay? Now, how many of you have heard the term living will? How about healthcare power of attorney? How about healthcare directive? What's the difference? No idea? In Minnesota, we have a document called a healthcare directive. If you're over 18, that's a document each one of us should have, appointing who we trust and giving some instructions about our healthcare preferences. Prior to 1996, we had two documents, healthcare power of attorney and living will. Our state just decided, that's just a lot to manage because healthcare power of attorney was after you were 18 up until you became terminally ill. Once you were terminally ill, then the living will took over. So our state just took those two documents and made them one, and we call it a healthcare directive, okay? And so, we use those words interchangeably sometimes, but if you're a Minnesotan, healthcare directive is what you want to have. It takes many different forms, okay? Meaning there's one out there that a lot of people use called the 5 wishes. I don't like that one personally, but if it works for a patient, great. There's something called honoring choices. That's one that most of the major healthcare systems, if not all, have standardized on. I like that one. Why? All the healthcare communities in our state recognize it. It's kind of like that statutory form. The Attorney General has a suggested one. The Archdiocese has a suggested form. I mean, it goes on and on. They're all acceptable, and so the main thing is that you find one that makes sense to you, that you are able to execute and clearly identify yourself as the patient, who you trust. Again, if you have 5 kids and you want them all to be involved in your healthcare decisions, is it a good idea to name all 5 of them with equal authority? No. Generally, no. Right? Why? Well, let's talk about that. Let's say you have 5 kids and patient has a stroke and provider says, we need to make a decision quickly about whether or not we intubate this patient to see if they can survive this brain injury, or we do not administer life-sustaining treatment to see if the patient can make it without support. 4 kids say, mom at 89 with a massive stroke wouldn't want that. 1 child says, only God can decide. You give mom everything, okay? They all have equal authority. What do you think happens in the medical community? Right? That's why it's not a great idea to put all those cooks in the kitchen, right? Now, if this child's right, and that is what was specified, but it wasn't specified, right? It wasn't clear under this circumstance what should happen. And that's a real life example. I didn't make that one up. But what happens is the medical community will always default to the most conservative course of treatment. You know, that's the Hippocratic oath, and also maybe a little bit of liability concerns on the part of the healthcare system, right? Because if somebody died without intervention, they might be subjecting themselves to liability by the child who believed mom should have received that treatment. So again, when you're setting the powers up, you want to be mindful of like the practical realities. What are we asking our agent to do, right? To be available potentially in a medical emergency. Let's say it's somebody living in assisted living. The agent is the person who might need to receive calls from the care team to say, you know, mom fell. We called the ambulance. We're taking her to the hospital, and alert, you know, that person so that they can go meet mom at the hospital and presumably make some decisions, okay? So you want to think about the practical realities of what that person's job would be, and then think about who would be good at that, right? And who would be willing and available. And I'm going to tell you, it's not always obvious, you know, but you hopefully, and what I mean by that is sometimes I have these kids that I meet with my clients during a family meeting, and I'm thinking, oh, here's the engineer, right? Pragmatic, sort of factual decision making, and probably would, you know, remove all the emotion and just make decisions based on the facts. And then we've got the school nurse who's like got a lot of practical experience. And then we've got maybe, I don't know, the teacher that's like really compassionate, and you know, and so I'm thinking, oh, go with the engineer, right? And then after a crisis situation or maybe a death, I'm not always right with what we, and so you know what I mean by that? Like sometimes death and dying and medical crisis just brings out behaviors that are totally unexpected. And the reason I mention that is just simply because the more instruction or conversation you can have with the people you're appointing, the more likely your directive is to be successful. And also you provide, this goes for your estate plan too, on the financial and the healthcare side. If you have done a good directive and your agent knows, okay, my job is to interpret the document and communicate to my mom's medical provider, then they're not making the decision. They're just telling the doctor what your decision was. And that's important when you're dealing with somebody who might be called upon to make an end-of-life decision, for example, because they're not then harboring the guilt of maybe feeling like they decided to end somebody's life. If you have already made the election, they're just communicating your preference, okay? So legally, the person you nominate should be able to segregate their own personal beliefs and wishes from yours, okay? That's really hard to do, you know, because we're human, but legally, the job is you take this directive and you communicate to the provider what that patient's preferences are, even if it's not yours, even if it's not. So for example, on the end-of-life spectrum, in my example, right? If this one knows that mom's preference was what these four are saying, and they're asking for treatment that's in contravention or against what they know mom wanted or is in the document, then they're breaching their duty, okay? So now, does that mean there's an automatic court trial and that child's going to be roasted? No. I mean, there's what the law says should happen, and then there's what actually happens, okay? There's what actually happens. Yeah.
Power of attorney for healthcare different than the one that we're talking about for your financial?
Yeah, so the healthcare directive is a totally different document, and it only, different people, it can be, or it doesn't, but it doesn't have to be. Sometimes people just pick the same person or persons, and sometimes they'll say, like I see some families that'll say, I'm gonna ask this child to be my primary healthcare agent and this one to be my financial agent, so they each have a responsibility. I have some people that just say, I want this person first on both, this person second on both, so you get the opportunity to make those choices. Not necessarily. I mean, they might, it could be in a case like this. They call the insurance company to pay a bill, and the insurance company says, well, you have the right to pay the bill, but because we're talking about protected health information and you're not the healthcare agent, we can't talk to you. So if it's the same person, they have authority for both. So in some cases, it can be an advantage, but it's not required. Okay? Did that example make sense? Like, if you're dealing with a medical bill, there's some medical privacy issues, and then there's who's going to pay the bill. And the privacy is the healthcare agent. The pay the bill is the power of attorney. So you remember, the legal and financial decisions are the power of attorney. The medical, where am I going to live? Which doctor am I going to see? Who gets to visit me? That's the healthcare agent. Okay? Did everybody hear that question? This is a good example. I'm gonna explain it, what I think I heard you say. Let's say son is on the power of attorney. He's responsible for paying the bills to the Fountains. Daughter's the healthcare agent. Fountains calls daughter, she's the healthcare agent, and said, we're at service level X, but we think we need to go to X plus 2 because we're noticing these changes in mom. We think she needs a little bit higher level of care. And daughter says, that makes sense, I'm going to authorize that. So her care plan changes. It goes up by $200 a month. Son gets the bill. What is this? What do you mean, extra stuff? I'm not paying for that. Could that happen? It could. Son would be wrong, right? Son doesn't get to decide whether or not that was an appropriate choice. His job is to pay for services received. That has happened before, but it would be resolved in favor of paying the bill, generally, because daughter had the authority to authorize the extra care. His job is to pay valid bills. That's a valid bill. Okay? So that's a good question. And again, it goes to when you're setting up your estate. If son and daughter don't see eye to eye, maybe that arrangement's not the best one, right? Maybe that's not the best one. Maybe it should be the same person on both in that case, okay? Although I'd be a little worried about son if he's not wanting to add the services. Sorry, I'm picking on the guys today, but. So let's see. I want to touch on, we're reaching the end of our hour, but this healthcare directive is the document that after you turn 18, you get to appoint one or more agents, you get to specify healthcare preferences, but it is signed by you in the presence of a notary or 2 witnesses. It is not a medical order. What's the difference? What's a medical order? It's signed, who is a medical order signed by? A medical professional, okay? And so, some people will say in their healthcare directive, if I'm found and I'm not breathing and I don't have a pulse, do not give me CPR. That's called a DNR, DNI. Do not resuscitate, do not intubate. You can put a sentence in your healthcare directive that says that. Let's say you have your healthcare directive on the front of your fridge and somebody finds you in your home and calls 911 and your preference is, I don't want CPR, okay? The emergency responders come and the person gives them your healthcare directive. Can emergency responders not do CPR with that set of facts? They give them your healthcare directive and it says, I don't want that. No, they have to do CPR. Why? Healthcare directive is not a medical order. Emergency responders can only not deliver life-sustaining treatment with a medical order that says, I don't want that, and my physician or nurse practitioner or physician assistant signed off on it, okay? So sometimes we will couple the healthcare directive with something called a POLST, P-O-L-S-T, POLST, which stands for Provider Order for life-sustaining treatment. Okay, POLST. That's a medical order. Okay, that's a form that you get from your medical clinic. You sit down with a medical person who would counsel you on what the choices are. Have you ever heard the term full code? Does anybody know what that means? Full code means that if a patient makes that election, full code, and they are found not breathing or without a pulse, they want everything and anything to try and sustain life, okay? Some people have the opposite. I don't want any life-sustaining treatment. And some people have a middle. You can try it, but if it doesn't look good, my agent could withdraw life-sustaining treatment, okay? So the POLST gives a patient an opportunity to be educated about those choices and make a decision so that if you're living in a senior housing community or at home, if you have a strong preference about end-of-life treatment, you should have a POLST. Now, my client who's 65 and getting ready to retire and, has maybe a couple health things they're managing, but is not terminally ill, not chronically ill, not thinking about death and dying, probably doesn't need a POLST, okay? But now what about my client who's 96, living independently, and during the pandemic called me and said, if I'm found in my senior apartment, I don't want CPR. I'm 96. There's this pandemic going around. I don't want CPR. I weigh 90 pounds. It would probably shatter all my ribs, and I'd be worse off. She should have a POLST, okay? So it really depends. Whether or not you need a POLST is an individual decision you make with your doctor, okay? It depends on where you are, okay? So you have a part 2 to this series. I'm part 1, I'm the lawyer part, talking about powers of attorney, touching a little bit on these healthcare documents. There's a second session coming up where you'll hear from a medical person through Fairview who will really get into the weeds on your healthcare directive and your POLST. This is just tonight to kind of compare and contrast to the financial directive, okay, so that you understand there's something over here for healthcare, a couple of documents, and then the power of attorney is all about your money, your real estate, anything you own, property, automobile, cabin, and both are important, right? Both are important. So, any questions for me? Yeah.
Clarify, I think you mentioned it before. It sounds like there are 2 different options if there's more than one power of attorney. One option is where they both need to agree.
Yep.
The other is if they work independently.
Yes. And so it's called joint. And on the statutory form, for example, the form says if you've named more than one person at any one spot, like primary, first successor, second successor, if there's more than one, you have to specify, must they act jointly? May they act independently? And there's a check spot for that on the form. Now, sometimes people, are tempted by the statutory form. They think, oh, this is easy. I'll just try and fill it out myself. And they leave that blank because they don't know what to do. If it's blank, the default is joint. So if somebody sets up a power of attorney and says, I want son and daughter, and they don't say, well, is it joint or independent? The default is always joint, right? Because that's more conservative, okay? So if you want independent, you actually have to say that. Has to say they may act independent of one another, okay? Yeah.
Quick follow-up, if there are 3 individuals and it's joint, can 2 of the 3 serve as majority, or does it have to be all 3?
Has to be all 3 unless somebody has died or become incapacitated. So, sometimes I have principal names spouse and 2 kids, for example, and spouse has died or becomes incapacitated. And if it's joint action, then obviously only the people who are alive and able to serve, but it's always joint. If there's 3 or 4 or 5, it would be everybody together. Okay, so. All right, well, did you learn something new? Yeah? Good. Well, you're welcome. Thank you. And happy to be back. And thank you to Hosanna and Mary and the crew for inviting me here to be with you.
Mary Frances, thank you so much.
Of course.